This episode of News from Poland Business and Law is for those willing to face the inevitable. The inheriting of property left by deceased foreigners and how foreigners may inherit property will be discussed by Marta Kacprowska, an attorney at law at Wardyński & Partners specializing in advising family businesses and foreign individual clients in inheritance proceedings. We will follow this with a brief summary of the current situation in the Polish economy. Our program is designed for foreigners acting as board members in Polish companies, foreign investors in Poland and their foreign advisors.
Hello. In our practice, we advise on matters such as estate planning and ensuring how specific property may reach legal successors in line with the deceased wishes. Inheritance from a foreigner in Poland generally follows the law of foreigner's nationality, but not always. If a foreigner is inheriting from Polish citizen, this is conducted in accordance with Polish law. A will enables property to be distributed in a way that excludes or modifies the statutory inheritance, rules that would apply under foreign as well as Polish law. Inheritance by will takes precedence over statutory inheritance. The law governing an inheritance proceedings and the appropriate court are determined based on the deceased's last place of habitual residence. European Union regulation allows a testator to decide that the inheritance proceedings for his or her property will be governed by the law of the testator country of citizenship, whether or not an European Union member state. The choice of law must be clearly and expressly stated in a will or in a separate declaration. The will or declaration will be regarded as valid if it meets the requirement of the country where the deceased had their last place of habitual residence or of the country of the deceased citizenship. The choice of law will facilitate inheritance proceedings if the deceased had a place of habitual residence in a country other than that of the deceased citizenship. In European Union countries, a special regulation of European Parliament governs which court should have jurisdiction over an inheritance case. Under the regulation, cross-border inheritance cases will be considered under the law of one state and by one authority. This is to prevent parallel proceedings in multiple countries and conflicting judicial rulings being issued. The special regulation has introduced the European Certificate of Succession, ECS. This document confirms that the heir has legal title to the inherited property. It is issued by a court or a notary. With this certificate, an heir can, for example, prove to the bank in another European Union state that the heir may take possession of the deceased funds at that bank. To administer property located abroad, there might be a need for the heir to present document confirming inheritance of the property. The European Certificate of Succession fulfills the same role in cross-border inheritance proceedings within the European Union, with the exception of Denmark and Ireland. If inheritance proceedings needs to be conducted following the death of a foreigner, Polish courts will have jurisdiction if the foreigner resided or had a place of regular abode in Poland, or if all or a majority of the assets in a state are located in Poland. Polish courts have exclusive jurisdiction in cases involving title to real estate in Poland. Therefore, if, for example, the deceased had real estate in Poland and savings in the United States, the proper court for the inheritance proceedings will be a Polish court. A similar situation will arise if most of the value of the estate involves shares in a Polish registered company owning real estate in Poland. If a Polish court jurisdiction has been established, the heirs should apply for a confirmation of acquisition of the inheritance to the district court appropriate for the location of the estate. The application should specify whether the estate is to be acquired based on a will or based on a statute. In certain instances, the inheritance procedure can also be carried out through a Polish notary. If the deceased estate includes debts, the application to confirm acquisition of the estate must state whether the heir intends to acquire the estate directly, namely without the limit of liability for debts, even if the debt exceeds the value of the assets, or with the benefit of inventory, meaning that the heir liability for debts will be limited to the value of the inherited assets. An heir might reject an inheritance. The declaration rejecting the inheritance must be filed within 6 months following the death of the deceased. Under European Union regulation, an heir might file such a declaration before a court in European Union member state where the heir resides, even if the court hearing the inheritance case is in a different European Union country. If the inheritance is not rejected by the above deadline, it will be deemed under Polish law as having been accepted with the benefit of the inventory. This might differ under foreign laws, meaning that there might be a full liability for debts, including Polish ones. A foreigner, namely a natural person without Polish citizenship or a legal person with a registered office abroad, may inherit real estate in Poland or shares in a Polish company that owns real estate. However, the act of the acquisition of real estate by foreigners may require, in some instances, the foreigner to obtain a permit from the Polish Minister of the Interior in order to acquire such assets. If the permit is not obtained, then the real estate will pass to the statutory heirs. There is no requirement to obtain a permit to acquire real estate if the foreigner is a citizen or a business of the European Economic Area, namely one of 27 member states of European Union, Iceland, Liechtenstein and Norway. A foreigner of country outside the EEA, for example United States, does not need a permit to acquire real estate or shares if the foreigner acquired inheritance through statutory inheritance. Whether the acquirer is a statutory heir is determined by the law of the deceased home country. If the estate was acquired through a will, a permit will not be acquired if the heir would also be entitled to statutory inheritance. Inheritance tax is waived for a foreigner who is an immediate family member of the deceased and has filed the appropriate tax declaration within 6 months. If the testator wish is that someone who is not an immediate family member should inherit assets that are based in Poland, then that heir will have to pay inheritance tax. If the foreigner was in an informal relationship with the deceased and the inheritance proceedings are conducted in Poland, that foreigner might inherit only through a will. Moreover, that companion, even if long-term, will not be included in a group that is exempt from inheritance tax.
Up till now, the Polish labour market has shown exceptional resilience in the face of various economic shocks and turbulences, such as the pandemic, the war in neighbouring Ukraine, and the significant rise in energy prices and inflation. However, symptoms are beginning to emerge, showing that the labour market is not only cooling down, but maybe slowly entering a phase of declining prospects. Unemployment is still at a record low, 4.8% in September, but for the first time in 2 years, significantly more companies are planning cuts in jobs instead of increases. However, radical changes in employment levels are quite unlikely, because companies will be reluctant to make redundancies for fear of having problems finding qualified staff once the economy recovers. Thank you for watching this episode. See you next time.